Okay, why don't we get started? I'd like to welcome everyone this afternoon to the presentation on intellectual property basics. We have received a lot of interest on this topic, and we are pleased to have Yuval Marcus as our presenter today. Yuval, do you want to switch the slide? My name is Charles Bishop. I'm a new volunteer at SCORE Westchester, which is hosting the presentation, and I'll be working on the webinar series going forward. A quick note on SCORE in case you're not familiar with the organization. SCORE is a national organization. There are over 300 chapters. The goal is really to foster and develop small businesses through free mentoring and education. And we work with businesses all the way from startup phase to already well established. One of the greatest assets of the SCORE organization is the mentoring program. The Westchester chapter has over 50 volunteer business members who have experience either through their own small business or through work at larger organizations. And they're there to help small businesses as their needs develop. And so there's a matching process where clients are assigned a mentor and able to take advantage of that resource. In addition, we do have webinars and workshops. We do plan to have some in-person events this year in addition to the webinar. And the webinars like today are recorded. You will receive a link later for review, or you can go on to our website, which is listed here, score.org/Westchester, to access this or previous presentations. Contact information is also listed here on the bottom of the screen. 914-267-6570 is the phone number. And if you would like to be informed of future events, you can follow us on the social media platforms that are listed as well. If you want to move to the next slide, we can talk about the housekeeping issues. Everyone except for the presenters will be muted during the presentation. We do, however, encourage you to ask questions. You may use the Q&A button at the bottom of the screen to submit questions. Today's presentation is going to be in 3 parts, and we plan to have questions after each part. So feel free during the presentations to go ahead and submit them, and we'll try to answer as many as we can. I'm going to switch to the next slide. I mentioned that this is an intellectual property discussion. There are 3 topics for today's presentations: patents, trademarks, and copyrights. And if we move to the next one. And we are fortunate to have with us today Yuval Marcus as our presenter. He is a partner and co-chair of the litigation practice group at Leeson Ellis, which is an intellectual property law firm based in Westchester. As you can see, he has extensive experience on this topic and is also a Westchester native. And in interest of time, I'll now turn the presentation over to him.
Great, thank you very much. I'm very thankful that you've invited me to speak today. Looking forward to sharing some insights on intellectual property. As mentioned, we're going to do this in 3 segments. First, we're going to do a little bit of overview in general what intellectual property is as sort of a category, and then we'll go through the 3 sort of major types of intellectual property, which are trademarks, patents, and copyrights. Let's start with what is intellectual property. So intellectual property, unlike real property, so you think of a piece of land, that's real property. You think of a factory, that's real property. Intellectual property, other than it's not a physical thing, it's intangible. It's something that comes from our brains, something that is that we're able to think about, and it adds value to our businesses. So it's really the knowledge, the ideas, the innovations and brands that give companies a competitive advantage. That's known as the general category of intellectual property. You can't touch it, but as we'll talk about today, you can create assets that have value, notwithstanding that it is an intangible asset. So within intellectual property, which is a pretty broad category, there are 3 major subsets of intellectual property. There are others too, but we're going to talk about the 3 major ones today, which are trademarks, patents, and copyrights. And each of these 3 things is different. And unfortunately, many people get these concepts confused, and they'll refer to something that really is a copyright as a trademark, or something as a patent as a copyright, or a copyright as a patent. There are 3 distinct theories. There are 3 different rationales for why these laws exist, and we'll go through that today. So as sort of a shorthand, just so you can think about it and what the differences are, think of trademarks as brands, patents as inventions, and copyrights as creative expression. Those are really the 3 hallmarks and what distinguishes them. There are some other differences. So whereas in order to have patent rights, you actually have to file a patent application, trademarks and copyrights, you can get protection even if you don't file any document with any government office. And we'll talk about that a little bit more as well. So let's start with trademarks. So as I mentioned before, trademarks are brands. But really what a trademark is, it's anything that can act as a source identifier for a product or a service. So what's covered by trademarks are words, names, symbols, devices, combinations thereof, and as we'll see in a few minutes, more than that, there are other things, pretty much anything that can cause a consumer to see it, think it, hear it, look at it, and say, okay, this product or this service comes from one source, can act as a trademark. And the trademark statute is there's a statute called the Lanham Act, and it protects trademarks, and it protects not just registered trademarks, but unregistered trademarks. And I'll talk a little bit about what the difference is between those 2 things. And really, it's a consumer protection statute. The idea behind the Lanham Act is that you don't want consumers to be confused when they see a product on the shelf in the store, that it's of lesser quality than what they're expecting. And so by protecting consumers, by having whatever is the identifier, the source identifier of that product will be associated with a particular quality that a consumer has come to expect. So really, confusion among consumers is really the hallmark of what is being tried to be prevented by the trademark laws. So we're going to talk about a couple of examples of trademarks. So at its most basic level, you have words, and and this is what's called plain block letters. So it's just words, and these can be protected as trademarks. You can also stylize the words, so add colors and stylization, and so you can get protection for the stylization if that sequence of colors for each letter is associated with one company. That can act as a trademark. Next, you have logos, and these are very well-known logos. I'm sure you all recognize them. But when you see that logo, you know that that product or that service is coming from a particular company. Same thing with slogans. Slogans can also act as trademarks. I'm sure most of you know, just do it. You hear that, you know that that's a Nike product or service, and I'm loving it. McDonald's, finger looking good, Kentucky Fried Chicken. These combinations of words have become uniquely associated with a particular company in connection with the particular products or services that they offer. In addition to words and logos, you can also have the product packaging can act as a trademark. So Tiffany uses this robin's egg blue color for its packaging, and you don't need to see the word Tiffany to know that this is a Tiffany product, because that color of that packaging has become associated uniquely with Tiffany. Similarly, the shape of the Coca-Cola bottle, excuse me, has also become associated. You see the shape of that bottle, and you know that that's a Coke product. The shape of products themselves, furniture can act as a trademark. So you see the shape of furniture, and that can also, it's called product configuration. Another example of another type of trademark is sound. So these musical notes are uniquely associated with GE, because those notes are GEC, and that's a trademark for what was, excuse me, General Electric Company back in the day. So now we see what can be trademarks. Not all trademarks are the same. Some are stronger than others. And most companies want to use a trademark that is descriptive. They want consumers to know what their product or service is. But from a trademark perspective, that's actually the worst thing you can do, because as you can see on this slide, descriptive marks are the weakest trademarks. The best trademarks, the strongest trademarks, are made up words, coined words, what we call fanciful terms. They are trademarks that don't have an association because they have no meaning, because they're made up. So the only association you can have with that word is with the companies that is offering a product or service. The next level of strength are arbitrary trademarks. Those are ones where the word exists. It's a common word in the English language, but it's not usually associated with a particular product or service. So for example, Apple for computers. Apple's a known word, but you would never associate, prior to the Apple computer creating it and that association, you would not associate the word Apple with computers. So that's an arbitrary mark. The next level is what's called suggestive marks. Those are marks that they suggest what the product or service is. So the example here is Jaguar for cars. Jaguar is associated with a fast animal, and cars are fast. So Jaguar suggests that it may be associated with a car product. And then the weakest marks are descriptive marks. Excuse me. The example here is American Airlines. That is descriptive for an airline in America, but through advertising and promotion, those descriptive words have become uniquely associated with one company. So you can get protection for descriptive marks, but you need to create what's called acquired distinctiveness or secondary meaning, where people associate those descriptive words with a particular company, not as sort of generically in connection, but descriptively of many possible companies. And then the last thing is generic. Generic is something that's not capable of trademark protection. So if you were to use the word Apple for apples, that's generic. You can't protect that. That is not capable of trademark protection. Now, so we've talked about what are good trademarks. Now, the way that many companies get into trouble is they just say, "Oh, we like this name." They start using it, and then they get a cease and desist letter because someone else has rights in that name. So the way to avoid that is to do a trademark clearance search. And there's a very common misconception that if their corporate name is available, that means that you can use that name as a trademark. That's not the case. That's not the end of the analysis. You need to do further investigation and searching to make sure that even if the domain name is available, even if you can register that name as a corporate entity, that you can use that name in commerce in connection with a good or service. So doing a Google search is not enough to do a proper clearance search for trademarks, because there are a number of different databases that you need to look at. It's highly recommended before you adopt and use a trademark that you do a trademark clearance search. Now, trademarks, as I said before, you don't need to file an application for trademark registration to have trademark rights. Trademark rights are created when you use a name in commerce. You sell a good or service and you use a name to brand that product or service. And this creates what are called common law rights, where you use a mark in connection with goods or services. You create common law rights, but your common law rights only extend to those geographic areas where you're using the mark in connection with those goods or services. So if you're a local business in New York and someone starts using that name in California, even though you used it first, you won't be able to stop that company in California because you're not using it in the same geographic area as them. The reason behind that is if you're not using it in their area, then consumers cannot be confused. And that's what trademark is designed to protect, is confusion among consumers. In the internet age, where everyone has a web page, the geographic distinctions have become smaller, but there's still part of the law of trademarks. But you can get nationwide trademark rights if you file an application for federal registration. You file that with the United States Patent and Trademark Office, and what that does is the moment you file that application, your rights extend throughout the entire country. And so you obviously your application has to get approved and you have to get registered, but your rights will go back to the day you file that application. If in certain circumstances, and will go back to your date of first use in other circumstances. And so there are definite benefits, as we'll talk about filing for federal trademark registration. So when you file the application, there are two types of applications you can file. You can file based on use if you're already using the mark in commerce, and you can file it based on intent to use. That means that you haven't used it yet, but you have a bona fide intention to use that trademark in the future. When you file an intent to use application, at some point you're going to have to prove that you're actually using it, and then your registration will issue, and your rights go back to the date you filed, not the date that you started using. Typically, you file the application, it gets examined in 6 to 9 months. Trademark Office is a little backed up these days. And the Trademark Office will then review it, determine whether or not they'll do a search of other trademarks that have been filed before you, and make a determination as to whether or not basically there's a mark that is close enough, which has similar goods or services that will block you from getting a registration. Sometimes what you have to do is, if they find something like that, they'll issue what's called an office action. And then you'll have 3 months to respond to that office action to make arguments as to why your application, your mark that you want registration for is not confusingly similar to that other mark that preceded you. After you get through that process and the Trademark Office signs off and says, okay, we'll let you through, there's a period where anyone can file an opposition to your application. Your application will actually get published in something called the Official Gazette, and that starts a 30-day clock for people to be able to file a opposition against your application. If no opposition is filed and your application is based on use, you'll get a registration. If it's based on intent to use, you'll have to prove use within 6 months. But that can be extended for up to 2.5 years. So that's the process in the Trademark Office. So there are a number of benefits to trademarks. A trademark has value. You can license it, you can sell it, you can use it as collateral to secure loans. So there's a lot of benefits to creating trademark rights. You have the right to stop competitors from using a name that is similar to yours for related goods or services. As mentioned before, registration creates additional rights. And if you continue to use a trademark, you can extend your protection indefinitely. So proper use of trademarks. There are two symbols. There's the R in the circle and there's the capital TM. R in the circle is for when you have a registered trademark, and TM is when you have a trademark that's unregistered, but you're claiming registered trademark rights in that term. When you use trademarks, you should use them as adjectives followed by a generic modifier, such as Pepsi soda. You don't want to say Pepsi's, you want to say Pepsi is the brand name, and then soda is the generic name for your product. So here are a few tips and takeaways on the trademark side. Create distinctive brand names, avoid descriptive names. One way to, if you want to describe what your product or service does, create a unique name and then use a descriptive tagline. That is a good alternative, because you can create brand equity in your unique name, but yet still tell your consumers what your product or service is. Definitely do clearance searches before you adopt a mark, so you don't get such a situation where you have a cease and desist letter get sent to you and you have to rebrand. And you should file trademarks with the applications with the USPTO, because there are a lot of benefits to doing so. With that, I'm going to stop here and answer any questions.
We have had a couple of questions come in, and just to remind people, if you join late, you can use the Q&A button at the bottom of the screen to ask questions. First question is really, how does how does the trademark, and this also applies to the other topics as well, apply in social media, given all the challenges associated with that?
So social media, just like anything else, trademark concepts, all the trademarks apply a lot in the context of social media, and so do copyrights. Patents, less so, but to the extent that you are, using someone's trademark name in social media, you can possibly social media. Can be a forum for infringing upon a third party's trademark rights. So you have to be very careful what you do. You don't want to do so. The prohibitions on the trademark side are not confusing people as to the source or the origin, right, of a product or good or service. And then there's also a branch of trademark law which stops you from doing something that might be confused, or consumers might be confused as to whether you're endorsing or sponsoring a product when you're not officially, licensed to do that. That can come up also in the context of social media. So that's one thing on the copyright side. Images are often shared, or links to things that you don't have the rights to. You can get liability there for copyright infringement. We'll talk more about copyrights in the third part of this program.
Okay. And then when should this process start? Does a business have to be up and running already, or if you have an idea and you want to see if you can get protection for a trademark associated with the idea, when is the best time to start the process for this?
So I would say that the answer to that is, as soon as if you have a name that you absolutely love, and that's what you really want to go out into the marketplace with, as soon as you have that name, I would do both a clearance search, and then if the clearance search comes back clean, file an intent to use application. That way, whether you'll be able to use that name going forward with some reasonable amount of certainty. And you'll also have reserved that name so that once your application is filed, if someone else, sees it out there and likes it, you can then stop them from using it if they're doing it in a competitive way for related goods and services.
And is this something that we have a question on the cost to do that? Is there a standard fee, or is it you need to hire someone to help you through this process?
Yeah, so the costs so there are two different types of clearance searches that you can do. One is what's called either a preliminary, or sometimes it's called a knockout search. What you're doing in a knockout search is you're just really looking at the database at the United States Patent and Trademark Office and trying to determine if someone has registered either the same or virtually identical name for very, very close or related services. It's really a first step to know, okay, yeah, there's no way I can go forward with this name. That search typically is it costs somewhere around between $250 and $500 to do that sort of preliminary search. The second kind of search is called a comprehensive search, and as I mentioned before, just because someone hasn't filed for a trademark application doesn't mean that they don't have common law rights. So in order for you to be, the knockout search is not going to find common law rights. It's just going to find registered right people who have applied. There are many companies that don't go through the process of filing an application, but yet they have these common law rights that they've acquired through use. And so a comprehensive search will go through a number of different databases to make sure that there are no common law uses out there that could potentially be a problem. And the cost of a comprehensive search is, typically, when we do them, we have an outside service that generates a report that we then review, and the whole search comes out to usually somewhere around $1,800. But which that may sound like a lot, but when you think about the fact that if you don't do it and you wind up launching a brand and then you have to rebrand, that, in my experience, is at least going to cost you $25,000 to $30,000 to rebrand. So you're better off spending some money up front to make sure you don't have a problem down the road. With respect to filing trademark applications, The application process, there's sort of usually there's you know, if you hire a law firm to do it, the law firm will charge you a service fee to prepare the application, and there's a filing fee. Usually the cost of getting on file is about $1,000, give or take, could be a little bit less, a little bit more. And then there's usually about $1,000 to $1,500 on the back end after you file your application to get to, you know, to respond to any office actions, to you know, to file a statement of use if you need to do that, and to get through the registration process.
Okay. We have more questions, but in the interest of time, I think we need to move on, and then we can come back at the end of the time.
Okay, that's fine. All right, so let's move on to patents. Okay, so as I said before, unlike copyrights and trademarks, patents, you need to file something in order to get rights. And excuse me, sorry. The patent, what patents do is they protect inventions, and they give you, the owner of a patent, the right to exclude others from making, using, selling, offering to sell, or importing an invention that is new and useful. And this, unlike trademark law, which is a consumer protection statute, this is designed to encourage innovation. And we'll talk about it in a minute, but actually the origins of patent laws are embedded in the United States Constitution. And so what happens is you get, as a patent owner, you can exclude others from making, using, selling, or importing for 20 years. And the patent statute is really a bargain that is being made by the government. We want to encourage people to disclose the best way to do something. If they come up with some innovation, we want the public to know about that, so that then we can build on that. And so the bargain that is struck is that you disclose to the world the best way to do something, a new innovative way of doing something, your invention. And in exchange for disclosing that and telling people how to do it, the patent office gives you the ability to stop others from making making and selling a product that is incorporates your invention. So that's the bargain, that's the exchange. And so the idea behind that is, well, and then typically what will happen is if you have something that's valuable, so there are a couple of routes that you can take. Like one is you can and we'll talk about whether you can actually make the product that is covered by your patent application, because there are limitations on that. But if you have the right, if someone else wants to make your patented invention, they will have to get your permission. And that typically will happen is that means that they'll have to pay a license fee in order to make it. And we'll talk about that in a little bit. But as I alluded to, just because you have a patent on an invention doesn't actually necessarily mean that you can actually make the product that is covered by your patent. And that is very counterintuitive, and it is often very misunderstood. And I'll give an example of that in a moment. But what it does do, patents, so you do not have a right to make what it is that you invented, because your invention could infringe upon the patent of somebody else. But what it does give you is the right to stop others from making what you've invented. So, and let's talk about what can be patented. So there are different categories of that can be subject of a patent application. It has to be something that's new and useful, but the categories in general terms are machines, articles of manufacturers. This is primarily like tools or things with non-moving parts, processes or methods. So the method of treating a disease, business methods, in some cases software. Though in these days, those types of patents are more challenging to obtain. And and then composition of matter, which is drugs and chemicals and things like that. But there's certain things that cannot be patented. So what things like laws of nature, physical phenomena, abstract ideas, scientific principles, and mathematical formulas. So these are not subject to the ability to get a patent. In general, there are three types of patents. There are utility patents, there are design patents, and then there are plant patents. Plant patents is typically something that is not very, it's very specific to particular industries, but utility patents are really, when people think of patents, they're thinking of utility patents. Utility patents are really patents that cover the way something works. And then within utility patents, there are really two different ways of filing a utility patent. There's something called a provisional patent application, and then there's something called a non-provisional patent application. So, and typically with startups or companies that are, just trying to launch, and they have a concept, they want to protect it, but they don't know whether it's going to be commercially successful yet. Typically, what will happen is they'll file the provisional patent application. So the provisional patent application, what it does is you get on file, you're able to establish that you had this invention as of this date and time, but it doesn't, your application will never be examined by the patent office unless within 1 year you convert it to a non-provisional patent application. And then the non-provisional patent application will eventually get examined by the patent office and potentially issue into a patent. So the question is why? So why would you file a provisional patent application? Because what it does is it essentially gives you a year to find out whether or not there's a commercial market for what you've invented. It gives you an opportunity to go and raise money. It gives you opportunity to, to see whether your idea is something that has any commercial value. And so many people, many small companies that are starting will file provisional patent applications. The downside to it is that it delays the time frame to get an issued patent. And you cannot enforce a patent application. If you want to sue someone for patent infringement, you have to have an issued patent. And just in terms of the time frame at the patent office, typically it is not uncommon for patent and so, as I said before, provisional applications do not get on the queue to even be examined. So when you file your non-provisional, it could take 2 to 3 years before it gets to the top of the pile where someone even looks at it. And then what will happen is the examiner will look at the application, and he may, and most of the time they'll reject most, if not all, the claims, and then you have to respond and argue why the claims should not be rejected. So the process is long. It takes a long time, so there are a lot of considerations you have to think about as to whether you want to file a provisional application or a non-provisional. There's also a way now to expedite your application. So if you file a non-provisional, you can pay additional money, and essentially, I kind of think of it as like the easy pass of patent applications. You can get yourself to the front of the line, or get to a much shorter line that goes through much quicker. And on the expedited patent application process, you will get to a decision of whether you're going to get a patent issued or not, usually within a year. So it's a much more streamlined process, but there's an extra cost, and it can be, the way patent office looks at things, it depends on how big of an entity you are, and they have different fees based on the size of the entity. But for like a small entity, it's around $3,000 to on top of all the other fees to expedite your patent application. Now, design patents cover the way products look. It's the aesthetics of a product, not the way it functions, but the way it looks. I'll show an example of that in a moment. Okay, so this is an example here of the Apple AirPods. Okay, and this is what we talk about when I said before how you can invent something, but you may not be able to actually sell the product that you invented. So the Apple AirPods, I'm sorry, have a unique way that they do it, but they use Bluetooth. Now, Bluetooth is a patented technology that Apple needs to have the ability to use in order for its AirPods to work. So typically what will happen in this situation is Apple needs to get a license from the whoever owns the rights to the Bluetooth technology before it can sell the product. Because just because Apple filed a patent and invented AirPods doesn't mean it can sell it, because if it needs Bluetooth technology to work, then without a license, it would infringe on the Bluetooth technology. So that's an example how you can have a patent on something, but you can't necessarily sell the product that is covered by your patent. If, however, you buy off-the-shelf products like from hardware vendors, usually there's a license built into that, so you don't have to go out and get a separate license. And so utility patents can cover new configurations of existing products. So again, this is all something you have to think about when you're trying to capture and cover and protect your inventions. Design patents, unlike utility patents, which last 20 years, design patents extend for 15 years, and they cover the design of the product, not the function, the aesthetics. Many of you may recall that there was a big lawsuit between Apple and Samsung. It went, there were many iterations and appeals. I think ultimately they settled that in 2018. But in the first ruling in this case, I think Apple was awarded over $1 billion in damages for Samsung, essentially copying the look of the iPhone and the rounded edges. And you see that that this is an example of how a design patent can be commercially valuable. So in order to get patent protection, the inventor has to do some things to protect their invention. They have to prepare a file and file an application with the patent office. Patent law is very specialized, and this is not something you can do. You need to be admitted to the patent bar in order to file patent applications. So you need to hire a patent attorney or a patent agent to file a patent application. And typically a patent application is, okay, there's a problem in the market. I've come up with a solution to that problem. And so your patent application should explain what the problem is and how you've solved that problem and how it's not been done before and how it's innovative. But as I explained before, the bargain is that we're going to teach the world the best way to do something, how to do your invention. So it has to be detailed enough that someone who is an expert in that area would know how to make the device. So you have to identify with particularity what your invention is. You can't sort of hide sort of like the secret sauce and get a valid patent. So what the patent office does is they'll then do a search for what's called prior art, meaning anything that was known prior to the filing date of your application. That's what's called prior art. And if there's prior art out there, they can reject your application or issue an office action rejecting your claim. So to get a patent, there are two primary things you need. You need novelty and non-obvious. Novelty means that it's something that is new. Non-obvious means that if there's something that existed, it would be obvious for someone who's in that field to do what you did, and that could be analogous to other areas. So these are sort of the standards to get in the door to get a patent application granted. So if you take one thing away from the patent discussion is, remember I said that you can, when you file a provisional application, you have a 1 year to file a non-provisional. The 1 year is very, very important because, and one of the reasons why you want to file a provisional application is that once you've disclosed your invention publicly, that starts a 1 year clock. If you don't file a patent application within 1 year of when you've disclosed your invention, you lose your patent rights. Let me say that again, because this is very, very important. If you've disclosed your invention publicly and do not file a patent application within 1 year, And this is the United States we're talking about. In some cases, if you do that, you lose your rights immediately. You don't have to. You don't have to have the benefit of the year. Well, let's focus on the U.S. If you have an invention, do not put it on social media. Do not publicly lecture about it. Do not write articles about it until you have first filed a patent application, if you are going to seek patent protection for that invention. This is probably the most important takeaway from today, is that because more often than not, we find people who say, oh, okay, I want to patent this, but they disclosed it and there's nothing we can do to help them. So anyway, that is the most important piece of the patent discussion. I'm up against I'm done with this portion of it, but we'll take questions now.
Yeah, we have a lot of questions on, will there be copies of the presentation available? And there will be a link sent to everyone for a copy of the presentation. Just a reminder, these are being recorded, and so you'll have access to the webinar through the SCORE website. I think we don't have a lot of patent specific questions, so maybe we should go through and do the last portion, then we can come back to answer some of the other questions that were asked before.
Okay, sure. Happy to move on. Okay, the last thing we're going to talk about today are copyrights. So copyrights again are based on language in the U.S. Constitution. They protect creative expression. They give the owner the right to prevent copying by others of original works of authorship. And again, the purpose is this is the language actually in the Constitution, to promote the progress of science and the useful arts by granting authors of original works of certain exclusive rights for a limited period of time. And we'll talk about the limited period of time. We saw that in the context of patents, it can be 20 years or 15 years. The term, the limited period of time for copyrights is much longer. So, and we'll get to that in a few minutes. There are a lot of different things that are covered by copyrights. So one example is computer code. Another is movies, photographs, paintings, music. And music has both the musical composition as well as the lyrics can be covered by copyrights. And then logos. And we had talked earlier about logos being covered by trademarks, because to the extent that they act as a source identifier for goods or services, they can be protected by trademark law. But they also, to the extent that they have requisite creativity, can also be protected by copyright law. So sometimes there are overlaps between the different types of intellectual property. Okay, so what is not copyrightable? So what's not copyrightable are ideas, facts. There's question of can you get a copyright on a telephone book, to the extent that anyone ever uses a telephone book anymore? But the answer is no, because all it is a series of names and numbers organized in alphabetical way. There's nothing there that is protectable by copyright. Processes and procedures and methods of operation not protectable by copyright, and short phrases and slogans or titles. So what do you need to get copyright protection? The work needs to be original, meaning you have to come up with it yourself. You can't have copied it from somebody else. And the threshold is a minimal level of creativity. It's a very low threshold. So as long as you've done something that has a little bit of creativity to it, that is an expression of something, generally speaking, you can get copyright protection for it. There obviously are some exceptions to that general rule. But the work is only the work must be what's called fixed in a tangible medium of expression. What does that mean? It means it can't be just in your head. It's got to be fixed in some way. Now that can mean written down. So to the extent that any of you are taking notes on this presentation today, whether you're doing it with a pen and paper, by putting the ink to the paper, you have fixed your expression of whatever idea in a tangible medium. So same thing if you're typing on a laptop, but when you type and you save your document, that is now fixed. And so your copyright, to the extent that there's the requisite amount of creativity, you have a copyright. You have copyright rights in your notes from today's presentation. Again, it has to be original, right? So to the extent that you're just, parroting my words and writing them down, you wouldn't have a copyright in that. It would have to be your original, thoughts on what I'm saying, and then fixed in a tangible medium. So who owns a copyright? So typically it's the author or creator. So, and this is a very, very important principle we'll talk about a little bit, but basically, if you create a work, absent other special circumstances we'll talk about, you own the copyright. If you created it, you own it. If it's fixed, it comes into being. You don't have to file anything. Once you create the work, you own it. If you work collaborating with someone, you can be co-authors or joint authors of a work. But here's the big exception to that, is if you are doing something for your employer, and you're doing it within the scope of your employment, generally speaking, the employer is the author and owns the copyright rights in what you create. So, but we'll talk about in a little bit what happens when you are you're not an employee, or you're a third party, you're an independent contractor. That creates a whole question of ownership of copyright rights. So what rights do you have? They refer to copyrights as a bundle of rights. You have the right to reproduce your work, to create derivative works, to distribute, to perform, and to display. Those are the bundle of rights that come in with a copyright. So this is a sort of a subtle thing, but it's important to understand. Ownership of the physical thing does not convey ownership of the copyright rights, right? So if you buy an original painting and you pay for it at a gallery and you hang it in your home, you own that piece of art, but you don't own the copyright in that artwork. So if you were then to take a photograph of the artwork and then try to put it on social media to promote something that you're doing in a commercial way, you'll be violating the copyright rights of the owner of the copyright, which could be the painter, or it could be, if he assigned his rights to a third party. So there's a distinction between owning the item and actually owning the copyright in the physical item, in the work that is displayed in the physical item. So as I mentioned before, you get copyright rights upon creation. You don't have to file anything. You don't have to publish anything. So your unpublished works, like if you never publish your notes from today's presentation, could be protected by copyright. So there are additional benefits, and we'll talk about filing a copyright application and getting registration. Unlike patents and trademarks, which are before the United States Patent and Trademark Office, there's a separate government body called the United States Copyright Office, which governs copyrights. And you can go to their website, copyright.gov. There is an electronic filing system called ECHO. Typical copyright application costs there's a filing fee of $65. When you file, you have to fill out a form, and then you have to submit a deposit copy of a sample of the work. There are different ways to do that for different types of works, and the Copyright Office has a lot of publications and circulars with detailed explanations. It's very, very complicated in the sense that there are a lot of different rules that you have to follow, and you have to make sure you're doing the right, using the right form and the right type of work, and that you're doing everything that you need to do the right way. You have to fill out certain information, so when it was it first published, and what does that mean, and when was it first created, and who's the author, who's the rights claimant. It's not exact rocket science, but there are some nuances that make it somewhat complicated. So, while you can do it on your own, it's probably best to consult with a copyright attorney to help you with that. Usually takes 6 to 9 months for the application to be reviewed. You can expedite service for a fee. I think it's around $800 to expedite. Typically, you would expedite in situations where someone's infringing and you want to get into federal court. Now, as I mentioned before, you don't have to file an application to have copyright rights, but having a copyright registration is very, very powerful. It does a number of things. It's prima facie evidence, meaning it's like a presumption if you're in a legal proceeding of ownership and of validity. If you're going to file for copyright infringement, you need to have a registration, or at least have applied for one. And then this is the most important thing. It makes statutory damages and attorney's fees available. When you're suing someone for copyright infringement, if you want to get damages, you have to prove that they have made profits attributable to the infringement. Sometimes that's very difficult to prove. And so if you have a registered work, and the copying occurs after the work is registered, you are eligible for what's called statutory damages, where you can get anywhere from the range is really 30,000 to 100,000, 150,000. I'm sorry, in statutory damages, where you don't have to prove that the infringer made profit off of the work. It's a scale based on sort of a lot of different factors, and it's discretionary, but that is important, so you can get damages, but you can also get your attorney's fees. As a prevailing party, it's not automatic, but it's within the court's discretion to award attorney's fees to the prevailing party. And that becomes very, very powerful. And the way this comes up in the business context most often is that someone decides, oh, okay, I'm going to put a photograph on my webpage, and doesn't get the permission to use that photograph. There's a band of lawyers out there who are using software to essentially monitor the internet for photographs that are being used, that they have clients that are photographers or photography agencies. They've registered all of their photographs, and then they go and they look for people who have taken their photographs and put them on the internet without permission. And then they'll typically send a cease and desist letter and say, we want, $5, $10, $25,000. You really have no defense, because copyright is strict liability. It doesn't matter that you were innocent, you didn't know that it was someone else's image. And if you go and you go forward with the lawsuit and don't pay them what they want, or negotiate it down to some number that they're willing to take, they can continue with the lawsuit. And if they win, which they're likely to, because you did copy the photograph, they can get attorney's fees. You would have to pay their attorney's fees. There's a lot of downside to that. So as a cautionary charge, is never put anything on the internet unless you know you have the rights to it. That's a big takeaway. So you can get also, if you have different versions of the work, you can copyright different versions as you go through it. But the biggest thing here is, if you have something of value that you think someone may infringe, and you're going to publicly display that work, you should get copyright protection, and never put anything on your website or in any publicly facing social media or anything like that, any photographs or other copyrighted material without getting permission first, because you really run a risk of a bad outcome. So as I mentioned before, copyrights last a long time. So if it's a work by an individual, it's the life of the author plus 70 years. So that can be well over 100 years. And if it's an employee work made for hire, it's 95 years from the date of publication, or 120 years from the date of creation. In any case, most of these copyrights last more than 100 years. And then when it expires, it enters the public domain. When you have a copyright, you don't have to do a copyright notice. There was a time where you had to have copyright notices, otherwise you lose rights. Here it's recommended you should do, copyright, the word copyright or abbreviation or the C in a circle, the year of first publication, and the name of the owner of the copyright. Works made for hire. This is another cautionary tale. When you hire a vendor to create anything creative for your company, so let's say a new logo or a website design, just because you pay them for their services doesn't mean that they transfer ownership of the copyright in what they created. And by default, the copyright resides with who creates it. So if you're hiring a third-party vendor or an independent contractor to create something for your company, unless you have specific agreement that says that the copyright ownership is transferred to your company, you don't own it. And this comes up a lot, and it's a very, very important thing that you want to make sure that anytime you hire a non-employee to create something creative that you're going to use in connection with your company, that you get an assignment of the copyrights as part of that agreement. Typically, they have the creative company has a form that they use, and they usually doesn't include transfer of the copyright. Some do, some don't. So with respect to infringement, there are two elements: ownership of the copyright and copying, and then you look to see whether or not the works are substantially similar, and that's a judgment call. And I've seen many things where I've looked at it and say, okay, yeah, this isn't. That comes from years of experience evaluating these kinds of things. You can attribute the name of who created the work, but that's not a defense. With that concludes the copyright portion. I'll take questions at this time.
Okay, we have a couple minutes. There are questions on AI generated content, and if those are copyright, if you can use copyrights on AI generated content.
So that's a very interesting issue. So some of you may have heard that there was a court case a couple of years ago about whether or not a monkey who took a selfie could be an author for purposes of the copyright statute. And the answer to that was no, only humans can be authors. And that is being applied as well to the AI context, so that if AI creates a work of art, the computer can't own it. So the AI brings up a whole host of questions. We could have a whole topic, whole program on AI and how it applies in the context of intellectual property law. But the answer to that question is no. AI cannot own a copyright.
Okay, I think we have time for one more question. There's several questions related to the timing of this. So if you've written a book or you've developed something, can you publish it before you get a copyright protection, or what would you recommend in terms of timing of using the materials you're filing for an application for?
So my recommendation would be that you should always file a copyright if you're writing a book or something like that. Ideally before you publicly release it, but if not, within 3 months of publication. There is a rule that if you file an application within 3 months of the first publication of a work, then you get protection going back to when the work was published. So, but I would recommend doing it before you publish. But if you can't for some reason, then file within 3 months.
Okay. If you can go to the last slide, I just want to make sure people are aware. One more. We do have here Yuval's email address. He's been kind enough to present that to us, along with the email address for Westchester SCORE if you have any questions. And you will be receiving a link to this, and that will include the request to mentor link below. I want to thank you. There's been a ton of interest in this topic. I know there was a lot of questions we weren't able to get to today, so you might get some inquiry coming in. but obviously very well received. Thank you so much. And I'd also like to thank the SBA for their support, which enables SCORE to help us put these presentations together.
Yeah, thank you. And I'm happy to answer questions. Feel free to email me. And thank you for giving me the opportunity to make this presentation today.